So I'm Dan Hunter. I'm the Dean of Swinburne Law School. My job was to kick the conference off and to talk about what is artificial intelligence and law, and to give an idea to the people, all of the delegates today, about the general significance, and to try to get them to start thinking about how it's going to affect their practice.
So, what possesses a law school to put someone with your incredible expertise on an issue, a seemingly niche in the perspective of some of our colleagues as AI, in such an important position? Do you think this is the way that most law schools will need to go?
Nice setup. Yeah, look, so lots of law schools won't. The thing about my law school, which is a little different, is we're not the incumbent. You know, we've only been in the market for 3 years, so we're brand new. What that means is that we have to do something different. It's a very crowded market. I come from a technology university. We're really strong in all sorts of engineering and design kind of areas and innovation areas. When we kind of took a look around and went, all right, so what is the future of law? The obvious question, or the obvious that is the obvious question. The obvious answer was, well, it's going to involve technology. It's going to involve an innovation mindset. It's going to involve a whole lot of things that are not old law, a whole lot of things that are not big law. And so what I'm trying to do is to get a better understanding about what is the future of law, so that I can work out what our students need in their legal degree.
Do you feel that as highly capable machines take over some of the, what I would call, the tip of the iceberg of the lawyer's role, so at the point of application, a lot of the practical stuff that goes on, do you feel that in fact there is kind of a push for law firms, not just to teach the technology, which of course changes rapidly, but to actually teach more timeless skills, and perhaps return to more theoretical and more philosophical styles of teaching?
Maybe we don't do that. I mean, and I am really pragmatic about this. I obviously want to give the students the ability to be able to learn in their new jobs and the jobs and the careers that they go out into. Some of that will involve having some sort of clear theoretical understanding about law, or what machines can do and those sorts of things. But generally, my interest is trying to understand what are the nature of the skills, what are the different sort of translational type of work that they're doing between technology and law, the very pragmatic things early on, because those skills actually will get students jobs, will get them noticed, they'll be different from other law students. I think any student at the moment who's coming into law school needs to be shown that there are possibilities in this space, that the legal profession is changing, but there are ways of making themselves future-proof. That's sort of what this conference is about. There aren't really any students here, which is a shame, but it just means that I've got to run more of these sorts of things in conjunction with you, Milan.
Absolutely. Can you reflect then on what you've taken away as an insight? Because obviously, actually, a few of the people I've spoken to on camera, and I can show you the evidence, have listed you as probably one of the better presentations today.
Thanks.
And I think that's because, according to many of them, you obviously tackled the introduction to AI, but did so in a way that respected their intelligence by sort of getting into the deeper issues. Mm-hmm. But was there anyone who you witnessed today that sort of left you with an insight you hadn't heard before?
I thought Karen's presentation was really great. I hadn't met her before. She's really interesting. Really practical kind of demonstration of the benefits of AI, but also a lot of the difficulties of actually implementing it and sort of demonstrating that in fact that AI is not the sort of the magic solution. The big problem working in this space is when you hear from vendors in whatever kind of environment, everything they say is, oh, it's amazing, and it's just, you sprinkle some magic AI dust on it and it's just going to be incredible. The only thing that's remotely as overhyped as that is the blockchain at the moment. So everybody sort of does that, and vendors are terrible presenters in these sorts of spaces. So I thought Karen's mix of discussion around, okay, so this works pretty well. In fact, lawyers don't really need to worry too much about this. That actually was an interesting observation.
I know that you touched upon this in reaction to something that someone in the crowd said, but in Wisconsin and Loomis, which is the case
Sure.
in the United States, and you might have to give a bit of background for the audience, but
Yeah.
one of the challenges that this gentleman made in his defense on appeal was that this sort of technology, this proprietary technology, which was a trade secret, was a black box and violated his due process rights because it applied inferences from a general set of people to him as an individual in the sentencing context, and also because it was hidden, and so the actual methodology couldn't be interrogated, and presumably this actually played a role in his sentence. Now, do you think there's an imperative for law students to understand this stuff beyond merely the commercial nature of their career in order to sort of safeguard rights like sort of due process rights and other civil liberties?
Yeah, so the Eric Loomis case, it was a situation about sentencing, right? So found guilty, he was sentenced. Part of the sentencing process in Wisconsin was that the judges had access to a system that in part predicted the likelihood of recidivism. This was this black box. Commercially available to the courts, sold to the courts, but because it was subject to a non-disclosure agreement and confidentiality, that there was no way of working out why the machine determined the likelihood of recidivism in the case of Eric Loomis. So went up to the Wisconsin Supreme Court, then application for cert at in the US Supreme Court denied. So we still don't know where it is. The upshot is that within Wisconsin at least, and increasingly across the United States, these sorts of predictive systems are available and legal and being used for sentencing. So the two things that you raise as issues are important theoretical issues, probably beyond the scope of most of what we talked about today in this, but they are important considerations in terms of two things. So one is, if you don't know why the thing is telling you something, can you trust it? Should you be able to ask for an explanation? What is the basis of it, and how much can, in this particular case, a criminal defendant be entitled to know the basis upon which he is being judged and, or in this case, sentenced? That gives rise to some pretty significant rule of law questions. The argument against that is, well, judges have largely unfettered discretion to sentence, although there are guides to sentencing in every jurisdiction. The judges are typically have a range, but within that range they can sentence hard or sentence soft. And if you talk to any criminal defence barrister or solicitor, I guarantee you that they will say their judgment to their assessment to their client. They'll take a look in, see who the magistrate is or who the bail justice is or whatever it is, and they'll say, oh God, okay, so it's going to be bad, you're going to go to jail today, you should be pleading guilty or whatever it might be, or no, it's going to be fine, this particular judge will listen to these particular pleas in mitigation, or these magistrates will listen to these pleas in mitigation. So there is a very significant rule of law issue around transparency of these sort of computer systems, and we're going to have a muscular analysis of this, and that's going to be something that's going to happen over the next few years. It's a mistake, in my view, to compare a computer system like this to a perfect rational human being, because there is no such thing. So we need to be aware of some of the issues in relation to that, but on both sides. The other point that you raised about Loomis and about the nature of these sorts of predictive systems is they're based on past information. So that past information might encode a whole lot of things that we're really not very happy with. For example, that in the case of the United States, African American defendants typically go to jail for much longer than white defendants, and if all the system is doing is encoding that particular discrimination, then it's a terrible system. The thing that typically you have with computer systems, which is really important, is that you can analyze the data that's going in, as long as it's not a closed black box, which we've sort of talked about a little bit. But if you're looking at the statistical basis of this thing, those data are available, and we can run all sorts of regressions on it and actually work out what the hell's going on with it. That's really, really valuable. That kind of sociological or socio-legal analysis is incredibly important. And computers can help you to do that. And those are the sorts of spaces where we actually discover that, in fact, our old ways of judging or our old ways of doing law are either really inefficient, really unjust, really, problematic. So, for every argument that, computers are going to take over these terrible things and do all sorts of awful things to us, there's a counter argument that sort of says, actually, it's going to expose and become a lot more transparent. So I think it's been a great day. Really, it's a fun time. This is kind of the stuff that I like doing. But more than that, I think it's really important for people to have a place where they can come and learn and express their concerns, or try to get a bit of a handle on how to think about this kind of stuff. There's such a lot of hype. There's such a lot of misinformation, and people are, I think they find it very difficult to get on top of how to think about these kind of things. So this event, the way it's been structured and the sort of people that have been involved, it's been really great to give the delegates and the people here the opportunity to start thinking this through for themselves. They won't come away with the solution, but they'll come away with better understanding about the way in which they might want to go about looking at this kind of thing. So it's really valuable. The more of these sorts of things we can have, the better.